Prospective overruling. The concept of the doctrine of prospective overruling was introduced in America. The term overruling means overturn or set aside a precedent that is existing, and prospective mean to something that only operate in the future, and prospective overruling mean a decision made in a particular case that will be effective or operational in the future and will not carry any retrospective effect on the past decisions. In the common law system, precedence acts to bridging the hollow between the traditional and contemporary law. In common law system, the retrospective operation of judgment was the part. Justice Cardozo and Justice Learned Hand had narrowed down the retrospective operation of judgment, and the American judicial system accepted the doctrine with two principles. One, Blackstonian view of law, that is traditional retrospective overruling, and two, prospective overruling. In the case of Great Northern Railway versus Sunburst Oil and Refining Company had articulated this doctrine by Justice Cardozo in the year 1932. Justice Cardozo viewed the non-application of this doctrine would cause grave injustice and will take away the dynamic nature of law. Let us now enter into the concept of this doctrine. This doctrine is the deviation from the traditional Blackstonian principle. In simple words, the doctrine is that the decision of a case would not have retrospective application but would operate in future. In an easy way, if we understand, then it will look like this. In a case, the court had overruled its earlier decision. In the present case, such overruling will not have any retrospective effect but will have prospective or future effect. The objective for restraining the retrospective effect is that it will cause serious effects on the past judgment, which in turn will cause hardship in the judicial and administrative system. It ensures that public interests are not to be affected by the invalidating the past actions under the law that have been declared unconstitutional. Retrospective overruling has only caused hardship to those who acted on the basis of the earlier ruling. In the other way, if we see, if a rule is given the retrospective effect in all the actions that occurred under old law would be deemed to be void and causes serious hardship to the parties who acted on it. So, it is necessary that the judgment or pronouncement of a court should be given prospective effect. American jurisprudence on this doctrine. Before the existence of this doctrine, American judicial system followed the Blackstonian legal theory. Under the Blackstone theory, the power of the court was restricted to the interpretation and expounding the law. The jurists of the other quarters were not happy with the situation, and the opposition had the thrust for the new development in the judicial system and had allowed the doctrine of prospective overruling. Jurist G.F. Canfield observed that it is the duty of a court to recognize and propound a new rule if the court deems that the old rule has become unsound or has lost effectiveness in the modern day legal system. British jurisprudence on this doctrine. Blackstone theory has been seriously criticized by the British jurists like Austin and Bentham. They do not agree with the Blackstone that court cannot make laws. Austin firmly sounded that judges be and will have the power to make laws to meet the time. The House of Lords Practice Statement Judicial Precedent in 1966 viewed that Blackstone theory do not stand with the time, and courts are to be given powers to amend, modify and also nullify the existing laws if it deem fit to do so. Indian jurisprudence on this doctrine. The Indian judiciary has acknowledged, adopted and invoked this doctrine in the case of I.C. Golaknath versus State of Punjab. Justice K. Subbarao, while harmonizing this doctrine with the notion propounded by Justice Cardozo in 1967 in I.C. Golaknath case, had propounded three important conditions for invoking this doctrine. 1. The application of this doctrine can be applied by the Supreme Court while in the matter of interpretation of the Constitution, and also can modify in respect of the cause before it. 2. While analyzing this principle, the judges of this bench had concluded that retrospective action will create serious problem in relation to the transaction taken earlier, so the doctrine of prospective overruling to be applied in the Golaknath case. 3. Constitutional amendment that already had taken will not be applied by this judgment, but only the future amendment will be affected. After the passing of the judgment of the I.C. Golaknath case, in various cases, the application of this doctrine was found. Some of them are: 1. Managing Director ECIL Hyderabad vs. Karunakar in 1993. 2. Harsh Dhingra vs. State of Haryana in 2001. 3. Union of India vs. Muhammad Ramjan Khan in 1990. 4. Keshavananda Bharati vs. State of Kerala in 1973. There is another famous case in the history of the Indian judicial commentary, that was Indira Shone versus Union of India in 1993, better known as Mandal case, where Justice B.J. Reddy ruled that the judgment of the said case will come into effect after 5 years from the date of passing of the judgment, and in the meantime, the subsequent cases will not be affected by the present case judgment.